I'm really correct.
But your lordship's direction is required for the purpose of preparation of paper book. To be mentioned.
My lordship to be mentioned for correction.
Grateful, grateful.
My lordship to be mentioned for correction. Grateful, my lord. Grateful.
All the list.
Item 1 to 4.
1 to 4.
Yes, Fendi.
See the report.
No, report perhaps it is not yet available. So what I am saying at this stage before.
Wait. Peruse report. In spite of intense search, the contempt applications are untraceable. Learned counsel offers to reconstruct the applications and place them on record. Leave is granted. Applications and any respondents filed anything?
Respondent get a change. Only one contempt order is there. It is a contempt application. Now the new incumbent has come. I know the name. If your lordship permits me, Lord, I can correct the cause title.
First, you record the original cause title.
Original one is there.
And then correct what we are asking, did the contemptor file any affidavit?
Nothing.
All right. Construction be reconstructed and filed before the department by Monday.
By Monday? By Monday file করে দিতে বলেছে। Then will correction of the cause title, if we not permit, I will not be in a position.
First, let it be placed before us. Then we'll permit you to change the.
Then it is to be listed. Will it will take long time? Time 13.
It will come Tuesday.
As your lordship.
Yes. And place and file it before the department by Monday. List on Tuesday.
Give already.
হলো তো?
Five.
Item 6.
Item 6 on for the state lordship. Lordship was directed to file a report by the IC. Why the petition not be registered today? Let's file a report, short for some more time. Lordship.
Why? What
That's a
more time?
report.
What more time? What more time? For 11 years is not enough. 11 years is not enough. A person absconding for 11 years and the IC wants more time. Report is placed on record. Report shows the accused is still absconding. He has been absconding for more than a decade. Superintendent of Police shall look into the matter and ensure apprehension of the absconding accused. Superintendent shall submit further report, adjourned 2 weeks.
Keep your vote. Murshidabad.
Seven.
But pursuant to the order My lord, I am the petitioner. My lord, 420, 406, pursuant to their lordship direction, my lord, I have complied with the notice served upon my lord 41A. My lord,
My lord, they met and they have stated that gold is with them and they will be returning it, my lord. They've accepted that.
So when will they return?
My lord,
my lord,
Get steal from another man and give it.
my lord, they are the goldsmith, my lord, they launched and
Goldsmith, now you have been caught here.
my lord,
You will go get gold from another customer.
no, my lord,
Account for that
my
and
lord,
then
give,
another case.
give me 2 weeks time, my lord. By that time, my lord, will refund.
How many cases against you?
No, no, nothing, my lord. Just saying, my lord, a long
Then
time.
2 weeks.
My lord.
Petitioner has cooperated with investigation. State seeks further time to recover the alleged stolen gold. Urgent 2 weeks.
My lord, deeply omitted.
Now your second case will start. কি হয়েছে কি?
Lord, I for the petition, my lord. The lordship has called for the counter case that, my lord, which we have lost.
You suffered fracture. You suffered fracture.
Lord, yes.
Not in the same incident, my lord.
Yes,
Not
yes.
in the same incident.
Not in the same.
According to them, they had gone there. There they were assaulted. They came back.
Came back.
Purportedly, we came to their house and assaulted them, where the husband's
The fact is they got it.
allegation is there, my lord. Yes.
If I may say it, it's a self-inflicted action.
Fracture.
কি বলছে শোন
Acha, because of the some party threw stone and got injured. All right, we have considered. Petitioner submit. There was a fight between two groups. Case, counter case was registered. Petitioner's associates have also suffered serious injuries. They pray for anticipatory bail. Learned public prosecutor opposed the prayer. He submits petitioners are dangerous persons. They had illegally encroached on government land. Thereafter, they assaulted the de facto complainant, resulting in serious injury and you were hospitalized?
Yes. No.
No. Serious injuries.
ওরা
There is possibility of commission of similar offense in future. Learned lawyer for de facto complainant submit. Oh, he also submits that injuries on the petitioner's associates are due to pelting of stones by their own men. Learned lawyer for de facto complainant submit that the case registered by the petitioners is not a counter case. We have considered the materials on record. Petitioner alleges, de facto complainant alleges petitioners came in a group and assaulted them and tried to grab their property. Full stop. Public prosecutor states that petitioners are land grabbers. They had illegally occupied government land. On the other hand, petitioners submit there was a free fight and both parties suffered injuries. Injury reports are placed on record. We have considered the materials in view of the aforesaid circumstances and the fact that both the parties suffered injuries. We are of the view custodial interrogation may not be necessary, but movement of petitioners required to be restricted in order to instill confidence in the mind of the de facto complainant and prevent commission of similar offences. Petitioners shall petition. Hirapur and that adjoining PS, what is that? Asansol South. Asansol South, na? You know it better. Outside the outside Asansol subdivision and provide the address, etc., etc.
Obliged, sir.
Yeah.
এবার আমরা এলে একই হবে।
Now your grabbing cannot be by your
They will-
main and agents are there.
Then they will grab my property.
Yes, to grab your property.
Your property.
Huh?
It's a government property.
No. You are also 751 is the plot. You are all unpartitioned property. They are claiming, and we are also claiming. Oblige me.
Subdivision outside essence. Next.
Sir, my lord, case counter case.
Injury.
My lord, I am for the de facto. 103 subsequently has been added.
Died.
Died. One died.
Surrender. We have considered the materials on record. Statements of witnesses show petitioners assaulted a number of victims. One of them died. In view of the nature of gravity of offense and involvement of the petitioners therein, we are not in.
Great.
Next.
Stop now.
11.
May I please, your lordship? Your lordship, report was called for. Another to report the reading.
Deputy Amit.
Who accused has been enlarged on bail. I'm the petitioner has been the owner of the vehicle. No prior antecedent. That's it.
There is a prior. We have considered the materials on record. Petitioner is the owner of the truck which is used for transportation of illegally mined sand. The vehicle was used for similar offense earlier. Under such circumstances, we are not inclined. to grant.
27 IPC 2527 Arms Act. Complaint was lodged on 2/7/21 against 30 to 35 unknown persons. Charge sheet was filed on 25/7/22. Most of them are on bail, and the co-accused has been granted anticipatory bail by the coordinate bench. I'm on the same footing.
You have criminal antecedents.
My lord, he's been absconding from 21, and my lord, criminal antecedent, my lord, I found out we couldn't find any. His name is transferring from the co-accused statement and the statement of the driver, my lord, which was hired, the car which was hired for this. And that is the statement of the driver, from where his name is transferred.
Dacoity.
My lord, Dacoity in the colliery.
क्या ऑर्डर दिया है एक मालिक to precarious position. Petitioner submits he has been falsely implicated. He prays for answerable bail and a lawyer opposes the prayer. We have considered the materials on record. Petitioner was a member of the gang of dacoits. He has been identified. His name transpires from the statement of the driver. Stuff. He has absconded for 3 years, more than 3 years. Accordingly, we are not inclined.
Great.
He does not stand on the same footing with Mohammed Akram, who is alleged to be receiver of stolen and has been granted access. Next.
So the complainant is the mother of the victim. But on the night intervening 12th and 13th of October 2024, the mother and the son, they retired to bed. At 3 a.m. at night, the mother heard a sound coming from the room of the son, but the son was sleeping. Mother entered the room, found that the son is lying unconscious. His hands and legs are tied with rope. So, thereafter, blood and the domestic articles are lying scattered in the room. He lost the complaint, obviously, blood. Nobody had been named in the complaint. Charge sheet has been filed against 5 persons, including the petitioner. It is on 21st of October 2024, outside the house of the petitioner, certain articles were recovered, which included the photocopy of the Aadhaar card of the victim. But this is the government sort of the story as per the petitioner.
How you have filed a charge sheet in this case?
Lord, 2 persons were already being arrested. One Swarup Kumar Sarkar and one Subroto Khan. Now, Lord, what has happened from the statement of Swarup Kumar Sarkar, what we found, that the vehicle by which they came to the place of occurrence to commit the offense, the vehicle belongs to him. Now, my lord, when the vehicle was seized from the vehicle inside, my lord, one ornament carrying pouch style as Prithvibhumi jewelers was recovered inside the vehicle, and that has been placed before the TI parade. In the TI parade, the wife of the victim has identified.
Our query to you is, you have filed a charge sheet.
My lord, we have filed the charge sheet.
Have you prayed for further investigation?
My lord, there is a supplementary prayer.
Huh? There is
A supplementary prayer.
prayer
Going,
for
yes, and the
going.
one of the warrant and proclamation attachment prayer has been made.
We are not at all considering warrant and proclamation and attachment. You have got ample evidence that you have filed the charge sheet. Don't you require custodial interrogation of this person?
Lord, the reason behind, my lord.
He is the owner of the vehicle. From his vehicle, jewelry belonging to the deceased family is recovered. He is not arrested. You have not interrogated him. You are filing a charge sheet.
Lord, until and unless I filed the charge sheet, the other two accused were.
Correct. So you should file a charge sheet, and did you ask for further investigation?
Not that prayer is there.
Is there prayer for further investigation?
If necessary, my lord, I produce the original case diary as well.
Original will not have a different prayer from the Xerox.
The order sheets as well from the current.
ও চার্জশিটের মধ্যে এসব এখন নেই
further investigation period.
See, you will prove in the trial. What you will prove in the trial? This is enough to prove in the trial that his vehicle was used to commit the crime.
And moreover, the statement also says that he was present with them. Thereafter, the Scorpio.
Whose statement?
One of the statement of the co-accused.
Then that will be enough. What sort of investigation is this?
Lord, I've gone through.
Huh?
Lord, I've gone through that. What I found, my lord.
No, that is exactly what is making us wonder. You have gone through, we understand the requirement of filing a charge sheet because the others may get statutory bail, but then in such situation, you will say that there is evidence, further evidence would be collected in the course of further investigation and supplementary charge sheet will be filed. No prayer like that. Mr. Basu would argue that where is the prayer for further investigation? No prayer for further investigation. And the evidence on which you would like to prove the case is that his vehicle was used for commission of the offense.
And the articles recovered of the keys, which has been identified by the wife. That's it.
Correct.
But if you lordship kindly comes to the DI parade once, along with the Caesar list.
All right, take down. Petitioner contends he was not named in the first information report. Nothing. He has been falsely implicated. He prays for anticipatory bail. Run a lawyer for the state opposed the prayer. He contends a group of the miscreants had gone to the residence to the victim's residence in a car. Petitioner is the owner of the car. Stolen article was recovered inside the car and identified by the victim's relations. We have considered the materials on record.
Dacoity with murder. The person died.
Deceased. We have considered the materials on record. One Mithun Chakraborty was found dead in his room. Various articles were seen strewn about. In course of investigation, co-accused were arrested. Complicity of the petitioner transpired. Investigation also reveals vehicle of the petitioner was used to take the miscreants to the place of occurrence. Stolen property was recovered from the vehicle, which has been identified by the relations. The aforesaid incriminating materials disclose complicity of the petitioner in the murder and robbery. Full stop. In view of the gravity of offense, we are not inclined to grant answer. These cases, there should always be a prayer for further investigation. This is relation. This is কি করে identify? Planchet করে.
My lord, I am for the petitioner. My lord, 108 and 34.
এখনো ট্রেন
Husband committed suicide, wife lodged 498A, and since 2023 she is
Who is
living.
the wife?
Wife is in custody. Wife is in custody. My lord.
Parents and other relatives.
Wife is living in a paternal house since 2023. Husband committed suicide in the December 2024, and for which wife has been arrested and in the custody.
Petitioner submits they are the parents-in-law of the deceased.
And my lord,
Their daughter was married to the deceased. She was subjected to cruelty and had withdrawn from the matrimonial home. A criminal case was lodged against the deceased, alleging cruelty. Subsequently, he committed suicide. His wife is in custody. Petitioners pray for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Petitioners are the parents-in-law of the victim.
there is 4 petitioners.
Petitioners are the in-laws of the victim. One and two are the parents. Petitioners are the in-laws of the victim. They have. It is contended they have been falsely roped in the case. Wife of the deceased is in custody. Keeping in mind the extent of their complicity in the crime, we are in fact contents.
Was no recovery from my possession. Only on
Unfortunately, my lord, proclamation has been issued. It's not maintainable anymore.
Petitioner is involved in dealing in narcotics. He uh, he had absconded and was not available for interrogation. Proclamation and attachment has been issued. Accordingly, we are not inclined to grant.
I'm for the petition of 18.
petitioner, my lord.
The statement.
For the allegation, my lord, under section, my lord, 85, 100, 3/1 and 3/5, my lord. My lord, I am the, my lord, petitioner number 1 is the, my lord, Ja, and the petitioner 2 is the her son, my lord, who is a, my lord, student. Marriage took place, my lord, 18 years before, my lord. But
How
I
did
have,
she die?
my lord,
Burning, my lord.
there is a burning, my lord.
Burning.
And 13 days after, my lord, FIR lost, my lord. I'm told, my lord, when she was offering her prayer, evening prayer before Tulsi Mocho, my lord, she caught fire, my lord. There was no access, my lord.
My lord, some witnesses implicated them, my lord, in their statement only.
Petitioners are the in-laws of the deceased wife. It is submitted she suffered accidental burn injuries and died. They pray for anticipatory bail. We have considered the materials on record. Any eyewitness?
No, my lord.
We have considered the materials on record. Statement of relations of the deceased say that they were informed over telephone that she had set herself on fire. However, other statements show she had suffered accidental burn. This is also recorded in the medical papers. In view of the aforesaid facts, we are inclined to grant it. Next.
Lordship, I am for the petitioner. Lordship, allegation against me, I have supplied spurious and adulterated ghee. And Lordship, from my house, Bonospati team recover. Has been sent for FSL.
We have considered the materials on record. Contraband articles, alleged adulterated articles have been recovered. Nothing is placed on record to show that they are harmful for human consumption. Under such circumstances, we are inclined to grant it.
Great.
Investigation pending.
Next.
Thank you.
May it please your lordship. My lord, for the convenience of your lordships, I have just made a comparison chart and a list of dates. দুটো দুটো করে দেওয়া আছে। My lord, this petitioner number one, he is the son of the petition of the de facto complainant. Now, my mother died. After that, my lord, I was holding properties jointly with my mother, and my father was also holding some properties jointly with my mother. So I thereafter, because there was after that he intended to again marry, and thereafter I filed a suit for partition, and I was also thereafter initially no injunction was granted but this honorable court thereafter granted injunction. My lord, he thereafter started threatening me. I have lodged GD entries. There has been cases under 107. Now, so far as the incident, he has filed a case against me. This is the case. I have also lodged another case against him. In that, he has granted
Died, person died.
No, my
No,
lord.
no, no, no.
Injury.
307 is the
What is
or-
the injury?
My lord, page medical page 4, 16 and 17, my lord. Mild lip injury, mild bleeding, chest pain.
Petitioner submits that there is big client, eh? No code banana. Petitioner submit that there is a dispute amongst the co-owners of the property. Case and counter case have been registered. They have been falsely implicated. Learned lawyer for the state opposed the player. We have considered the materials on record. There is prior enmity among the parties. The injury report does not disclose grievous injury. Under such circumstances, we are retracting.
I'm deep. Deep.
There. The farms look here. Oxy. 22.
First, I beg to appear on behalf of the petitioners. The allegation under section 103 and 61 subclause 2 of the BNS Act. Although lordship, this case is registered for murder, but lordship, while granting bail to the principal accused who actually stayed with the deceased on the date of incident, it has been observed by the learned sessions that this is not a case of murder. Maybe it is a suicidal. Page number 16.
The dead body was found from the hotel's room in a hanging condition. Due to hanging. Now, if your lordship sees the postmortem report,
So for petitioner number 2 is concerned, he was not at all. Petitioner number 1 is concerned, he was not at all present. That will
Who were present?
Alleged accused number 1 and 4.
Petitioner number 2 was
Who was present in the hotel?
lordship, there are 5 accused persons. Tanushree Mukherjee was known to the victim. Lordship, Tanushree, this petitioner, and this petitioner number 1 and the victim, those 3 stayed in a room.
Petitioner number 1, Tanushree,
and the victim,
and the deceased.
No, lordship. Kindly see page number 13 once. 3.
That is the
Yeah.
statement.
No, what is written? The Abul Nashar is the deceased. He went with 3 persons: Tanushree Mukherjee, Shoma Mukherjee, and the driver Ataur Mondol. And the deceased stayed with Tanushree Mukherjee in the room. And Tanushree Mukherjee was arrested and subsequently granted bail. And so far, the petitioner number 1 is concerned, Krishna Pandit. Against him, allegation is this: there was some earlier dispute. On earlier occasion, some dispute took place against him. That is the implication.
Lordship, if your lordship kindly sees page 199, that is the statement of the wife of the deceased. 199.
Tanushree Mukherjee was arrested, my lord. Subsequently granted bail, and I have annexed that order also at page number 16.
And petitioner submits that The victim, the deceased had committed suicide in a hotel room. They were not present in the room. They have been falsely implicated. They pray for anti bail, and a lawyer for the state opposed the prayer for anti bail. We have considered the materials on record. Petitioner and his friend what Ata?
This is the driver is Ataur
Mondol.
Mondol.
Petitioner and his friend Ataur Mondol, along with one Tanushree Mukherjee and petitioner number 2 Shoma Banerjee, went to a hotel. In the hotel room, petitioner committed suicide. In the hotel room, petitioner suffered unnatural death. Postmortem report shows death is due to antemortem hanging, which is ordinarily suicidal. It appears Tanushree Mukherjee was present was sharing the room with the petitioner. She was arrested and has been released on bail. Petitioner number 2 and Ataur Mondol, Ataur Mondol were in another room, and it cannot be said that they were privy to the circumstances leading to the unnatural death of the deceased. Petitioner number 1 was not present at the spot.
No, Lordship. Petitioner number 2 was not present. Petitioner number 1 was there.
Where?
Lordship, petitioner number 2 was not allowed to enter in the hotel because he had no identity card.
He is saying that petitioner number 2 was researched with Atar Mondol.
Homa Banerjee was not there.
Kindly see page number 13, the FIR, Lordship.
Petitioner number 1 was not present at the spot, and he has been falsely implicated out of mere suspicion. Under such circumstances, we are inclined to grant answer. Hello. Grateful. Next.
23, we are appearing for
Yeah, right.
This is a second application. My lord, second application. But before charge sheet, the petition was rejected, and after filing the charge sheet, I didn't get any change of circumstances.
Petitioner, this is a subsequent application for pre-arrest bail. It is contended charge sheet has been filed. Filing of charge sheet is an aggravating and not a mitigating circumstance. Hence, we are not inclined to review the earlier decision to earlier order rejecting the prayer for pre-arrest bail. Reconsider our earlier order. Next.
By 24, my lord, I am for the petitioners. But 316 and 85 of the PNS, section 35 notice was served. But due to the section petition number 2 is the cancer patient, due to his treatment, my lord, we could not comply that. My lord, we communicate to the IO and prayed for the further time so that we can comply with the notice.
There's no compliance of 41A. Notice was served to him duly.
Petitioner, we have considered the
There are allegations of dowry demands.
Allegations of torture are general and omnibus. Under such circumstances, we are of the opinion custodial interrogation is not necessary. But petitioner number 1, husband, request to cooperate with the investigation in accordance with law. 10,000 to share this. Petitioner number 1 shall meet investigating officer once in a week and further.
Good.
Next.
Madam, for the petitioner, the allegation under section 126 to 115 to 112 to 110 and 35 of the BNSS Miller. The petitioner happens to be the uncle of the
110 is 308.
308.
My lord,
We have considered materials on record.
the victim is in disabled 75% intellectual.
We have considered the materials on record. Dispute arose amongst family members. Though victim is a person with special needs, Injuries do not appear to be life-threatening. Accordingly, we are inclined to grant answer.
Extremely grateful.
It's 26. Fighting between two adjacent neighbors. Fighting between two adjacent neighbors with regard to partitions of their land. Who accused were granted anticipatory bail from the petition.
My lord,
All are family members.
38, one received 38 stitches on head, one entire knee, that patella is broken, and another received head injury and fracture on scapula. Three injured, three grievous injuries.
We have considered we have considered the materials on record. Statements of witnesses show petitioners assaulted number of victims. They suffered grievous injuries, including fracture. Accordingly, we are not inclined to grant answer. Next.
The allegations under section 329, 464, 1, 62, 351, 3 and 35 of the BNS. There is a monetary dispute regarding a shop room between the de facto complainant husband and the accused persons. There is a 1 month delay approximately in lodging the FIR. I have served my lord, but perhaps it has not been served.
Victim notice.
Got you.
Notice to victim. Not one victim.
Yes, Madam.
My lord, I am for the petitioner.
Yes. NDPS rejected.
My lord, 13 kg 500 gram gaja was recovered from one Manik Sheikh. From his statement, the petitioners process under section 82 and 83 CRPC
Consider materials on record. Quantity of narcotics recovered from co-accused is below commercial quantity.
But he is the
No
supplier.
narcotics was recovered from petitioner.
Nothing has been recovered.
Its complicity transpired from statement of co-accused before police officer, which is inadmissible in evidence. Accordingly, we are inclined to grant answer.
30 for the petition. Allegation the victim girl on the way of school, tuition, private tuition kidnapped at 3 p.m. And at 6 p.m. return back by home safely, that is safely. আমার অপহৃত মেয়ে নাবালিকা মেয়ে নিরাপদে উদ্ধার হইয়াছে। Kindly see the last line of the FIR, my lord. আমার নাবালিকা মেয়ে অপহৃত নাবালিকা মেয়ে নিরাপদে বাড়ি ফিরে এসেছে। That is the allegation.
petitioner and they went to some place.
To
This is
Bihar,
yes.
Katihar, Bihar.
He is a
As per allegation, my lord, the kidnapped
16
3
years.
p.m. and return back at night, my lord.
No, 15
Six-
days. 15 days.
Where you go to Katihar, Manikchok to Katihar in
Yes, yes.
3 hours.
For
Well,
15 days they stayed there.
Kindly see the FIR, my lord, the FIR sees, my lord, the
We have
A
considered
civic
the
volunteer recovered.
my lord, FIR,
kidnapped the minor girl and taken her outside the state. Hence, we are not inclined to grant it.
my lord, FIR last line they say
নিরাপদে ফিরিয়ে আসে।
হ্যাঁ my lord, my lord, see the নিরাপদে ফিরিয়ে
নিরাপদে বাড়ি যাও।
আরে আজকে আপনার বলে তুমি আছো ওই জন্য আমি তোমার ওই দাদাকে বুঝতে পারি আরে
অশোক দাসও
হ্যাঁ well, I am for the petitioner. There is a case and counter. The case and counter case, my lord. I have filed earlier. But there are 5, my lord.
Multiple hit on the face by Hashua, on occipital region.
Dispute regarding land. There is a case and counter case. Our case is earlier.
Consider the materials on record. There is dispute. There is a land dispute amongst parties. Though petitioner used a top-cutting weapon to assault the victim, injuries are simple. Accordingly, we are inclined to grant it. Next.
32, I am for the petitioner lordship allegation under section 109, 117 to 126 to 351 3 and 35 of the
Yes,
BNS
Mr.
Act.
Chakraborty.
Lordship charge sheet submitted against 5
According
persons.
to case diary, my lord, and the statement of the injured Rajat Mondal assaulted, and my lord, Rajat Mondal has been granted anticipatory bail order annexed. But my lord, his prayer has been turned down. I do not know why by the learned sessions judge by saying that he is the person who assaulted.
We have considered the materials on record. Co-accused Rajat Mondal has been granted anticipatory bail by the sessions judge. In view of the facts and circumstances of the case, custodial interrogation of petitioner is not necessary and he may be granted.
Lordship grant me leave to correct the cost title.
Correct the first. Next. 33.
Lord, I am appealing for the petition. And on 17th of October, a commotion took place with regard to the immersion of the deities. That petition number 1 to
We have considered the materials on record. Statement of witnesses show involvement of show petitioners assaulted the victim, resulting in serious grievous injury on the head, and grievous internal injury on the head. Victim was hospitalized. Accordingly, we are not inclined to grant it.
But it is 34, my lord, I am for the petitioner. But due to personal, my lord, loan, the case has been started, case and counter case. I have given, my lord, all the documents. Our case number is 78. 78, their case number is 84. 82. Personal loan. It is alleged that I have taken some amount.
And then they come and you beat him.
Nah, they beat me. They beat us. That is why I firstly, my lord, made complaint. And accordingly, a case has been started 78. Our case number is 78. Their case number is 82. And my lord, I have already repaid some amount of money. My lord, it may kindly fixed on Monday, my lord.
Monday. 35. Joydeep.
35, I am for the petition. Lord, 420, I am the, my lord, postpone. My lord, now in this case, what has happened, my lord? My case is this, my lord, the post office never, my lord, issues handwritten passbook, my lord. My lord, everything is entered, my lord, through a software. My lord, I have given explanation to that effect to the police also. My lord, that, my lord, it is being used a pinnacle system, my lord, wherein, my lord, the passbooks are printed and thereafter handed over. The passbook which has been produced by the, my lord, de facto complainant, my lord, it's a, my lord, handwritten passbook. My lord, we have never, my lord, written anything, my lord, on the passbook. Neither any stamp has been given from our office.
What is the allegation?
Allegation that, my lord, he has deposited the amount. My lord, when he went to withdraw with those, my lord, handwritten passbook, my lord, it was denied.
My lord,
Complainant opened 7 accounts along with his family members. Total deposited amount was 12,20,000. When his mother was detected cancer, he went to the post office to withdraw the amount. Then, my lord, the postmaster there refused that there is no such account. Then he placed his passbook and other documents which was with him while he opened the account. Thereafter, my lord, he lodged a complaint with the PS. That was not entertained. Thereafter, my lord, he filed a court complaint and my lord, FIR was registered. And my lord, thereafter, the documents procured from the post office is that the account number are same, but the name of the account holders are different. My lord, the passbook which they are holding, account number and name are of them. But my lord, when it was inquired with the post office, the account number is same, but the account holder name is different.
Whom is there? Who gave them the passbook?
My lord, the postmaster.
Which postmaster?
My lord, Jamalpur sub post office. The sub postmaster of Jamalpur sub post office. My lord, I am placing the documents, my
Is
lord.
there any document to show that the passbooks were handed over to them? Is there in the records that passbook is handed over, passbook page so and so to so and so hand?
My lord, the sub postmaster has his signature over the passbook. That is there.
That is what we are saying.
My lord.
Signature is genuine.
My lord, that the investigation is required, and my lord, the case has been transferred to CID as per the order of the High Court.
Why arrest?
I have already cooperated, my lord.
He is the postmaster.
My lord.
The sub postmaster signature is there.
My lord, he is the sub postmaster, and his signature is in the passbook.
So have you compared his signature?
My lord, the concerned PS has done nothing. That is why, my lord, they have filed a writ petition.
Deposit 12 lakhs.
My lord, money I have not taken, my lord. Those passbooks, my lord, are of, my lord, handwritten passbooks, my lord. Now,
if they are in the first.
my lord, I have said.
Let them verify. You verify the signature.
My lord. My lord.
Petitioner is offers to cooperate with investigation and hand over signature and handwriting for verification. Report be filed showing whether petitioner's signature appears in the fake passbook or not. How many? 4 weeks?
My lord, 4 weeks.
Or till such time, my lord, I will not be disturbed.
Who is arresting you? Nobody. You are like friend of the police. Not to arrest.
আমাকে দেখে একবার আমার দেখে স্পেসিফিকটা
কত আয়েগা? Next.
Your Lordship's
admitted.
Your Lordship, section 302/34 IPC. Admitted.
Next matter.
Delay by 96 days. Similar matter has already been admitted.
Delay condoned.
96 days.
Delay condoned. Issue usual notices. Appeal shall be heard along with CRS ones.
দিয়ে দিচ্ছি আমি ওটা সিরিয়াল নাম্বার কত
Next,
ওটা দিয়ে যাচ্ছি আমি দিয়ে যাচ্ছি না লিবার্টি মে ক্যান বি গিভেন
suspension of sentence. 38,
I love it.
39.
39, Lord, I am making appeal to your lordship. Kindly adjourn for a week, Lord.
Why?
Because advocate records that is Rohan Doipa and Dhomik, he has gone to doctor for medical checkup, Lord.
We don't require their assistance.
I am not in this matter, Lord.
We don't require their assistance.
Oh.
Admitted. Issue usual notices. Call for records. Liberty to pray for suspension.
I'm grateful. I'm grateful.
Next.
Manami the was collected.
My lord, in time 302 conviction along with arms.
How many juniors now? Four. Four. Now you are senior. You should have 10. Huh? At least 10. And next. Usual notices.
Lordship, there's an application for addition of name of the accused.
Yes.
There's an application for addition of name of the accused. Inadvertently, it has been missed out.
Name of the
Accused, KM.
respondent be added.
I'm grateful, Your Lordship.
Array of respondents. Application is disposed of.
Grateful. Your Lordship.
Necessary amendment be carried out in the course of the week. Yes.
What is a restoration application, my lord? For the state. Restoration application, my lord, I was not present on, my lord, 12th February, my lord. Is a CRAN application was there, my lord?
What
My CRAN. My lord, restored the CRAN 2 application, my lord.
CRAN 2 was for relaxation.
Relaxation was there, my lord.
Applied with condition too.
CRAN 3.
No, my lord, that is a relaxation. That is a my lord, relaxation for surrender before the learned court below, my lord.
Alright.
He could not
We
appear at this time, my lord.
recalled, order recalled, petitioners could not surrender. এবার CRAN 2 টা হচ্ছে যে recalled, CRAN 3 এ লেখো. Petitioners could not surrender before the jurisdictional court and pay for regular bail due to circumstances beyond control. They are directed to surrender within 4 weeks and pay for regular bail, no further extension.
I'm grateful.
Grateful, Lordship.
Next.
কি গো আমার আমি তো আর তো কারো নাম দরকার না আমি তো এসেছি আমার নাম দিলি না
My lord, I am for the petitioner.
Yes.
My lord, I am grateful to have your lordship's order of anticipatory bail on 6th February 2025, my lord,
Yes.
for the 8 accused persons.
Yes.
Subsequently, by another order,
What do you
another
want?
order
Tell
dated
us.
19th February, I got the similar order, my lord.
What do you want?
My lord, actually, after getting this order, while my client, the petitioners are appearing before the learned court in Chinsuda, the local bar, some of the advocates of the local bar.
Give the names. Give the name.
My lord, I personally, I do not know them, but whatever the information I have received, my lord, actually, I was there personally.
Then give the names.
My lord, secretary is Subhashis Chandra
Petitioners submit
and Mr. Osid Majhi, assistant secretary.
that they were not permitted to surrender before the jurisdictional court and pray for
But
regular.
actually, the de facto complainant is the advocate.
Yes.
Sorry, my lord.
Right to access to justice is a fundamental right. You cannot be scuttled by obstruction.
Naam designation.
By obstruction from lawyers who are officers of the court. Stop. Under such circumstances, we direct Secretary District Legal Services Authority to give assistance to the petitioners so that they may appear and pray for regular bail before the jurisdictional court. Full stop. Matter will appear, petitioners shall appear and pay for regular bail within 4 weeks from date. Secretary District Legal Services Authority shall submit report on the adjourned date. 6 weeks. Alright. Relaxation, Mrityunjay.
My lord, what happened here? 3% was before your lordship at that time.
Within 4 weeks times.
4 weeks time. Thereafter, another. My lord, I'm saying, my lord, what happened? Thereafter, my lord, another FIR lodged. My lord was pleased to grant anticipatory bail on 6th. 7th, another case he has been arrested. This is extension.
Huh?
This for extension, my lord. He has not.
Now you are on bail.
Now I am on bail, my lord.
Petitioner was unable to appear and pay for regular bail due to circumstance beyond his control. Let the he is directed to surrender within 4 weeks from date.
My lord,
who you want?
2 weeks I can surrender.
We are saying 4 weeks.
Well, my lord, what I am submitting 3% before your lordship at the time of anticipatory bail. Now 2 surrendered, 1 is here.
Petitioner number?
My lord, Sheikh Shahjahan I mentioned, my lord.
What is petitioner number?
Petitioner number 3, my lord.
3/applicant. Huh?
Applicant, 1 applicant. Grateful.
Petitioner number 3/applicant.
Grateful, my lord.
Yes.
Please, my lord. My lord, conviction under my lord 424.
103.
My lord, 467, 468, 471, and 13(1)(d). My lord, it's up to 10 years, my lord, only in 467. My lord, I'm in custody.
Mr. Rudra.
My lord, the last occasion also, my lord, time was taken, my lord. I'm in custody over 3 years, my lord.
Then?
And 71-year-old man, my lord. My lord, can you grant me suspension, my lord?
Huh?
It's suspension only, my lord. I'm not on appeal.
Appellant is a septuagenarian. He contends he has suffered detention for 3 years out of substantive sentence of 10 years. He argues there are he submits that there are arguable issues raised in the appeal. Possibility of the appeal being heard out in near future is bleak. Under such circumstances and in view of Bhagwan Shinde so and so, we are inclined to suspend.
But same order maybe next. In the next
How many?
2 cases, my lord. 16 checks in 2 cases.
Total amount 2 crores.
No, my lord. Most of the checks were dishonored.
Ah.
10 years.
Both 10 years. Both. Same.
How many trials you're facing? How many?
Only these 2. Only these 2, my lord.
Next matter.
Your Lordship, this is the report.
You have intimated.
Victim girl was
Intimated.
এটা রেখে দিন আগেরটা
My lord, 12 years and 1 month in custody. My lord, 302. My lord, I only beseech your lordship to see my lord, these are the exhibits, my lord. Flag mark before the doctor, the wife said herself, she suffered accidental burn injuries. Thrice. First, she was taken to Shambhunath Pandit. From there, she was taken to MR Bangur. At both the hospitals, my lord, the flag part. She stated about accidental burn. 3 days later, my lord, the parents and the police come into play. Now the police records a statement that she was doused with kerosene. The doctor in front of whom the statement was recorded, the doctor is never examined. Now, the independent witnesses, my lord, this is the evidence of the independent witness, PW10. My lord, he and also PW9, the taxi driver in whose taxi the lady was taken, they say that the lady herself stated that she suffered accidental burns. It evidence. The minor son was present in cross-examination. The minor son, my lord, PW1 takes a complete U-turn and says that how he was tutored to make statements. The cross-examination of the minor son. And the learned judge has recorded that and has disbelieved the evidence of the son also. If she is first examined in MR Bangur, Shambhunath Pandit, 6th and 7th in Shambhunath Pandit, all statements she makes that accidental burn. 8th onwards, the police come into the picture and that is where the statements change.
डिपोजिशन करने में टाइम अरे हम क्या बोले हम तो कुछ बोल
12 years, 1 month already in custody.
No.
My lord, kindly see. My lord, kindly sees the document.
Come to internal page 17, PW 15.
PW 15. Yes. It was a case of, my lord, first your lordship sees, she said herself suicide, then she changed it to accident. Kindly see 3 dates. 5.
It's a suicide, not accidental.
My lord, that is also stated. Doctor has recorded. I have flagged that suicide. My lord, green flags I have put.
Were they exhibited?
Yes, my lord, exhibit 11. Yes.
Where is the dying declaration?
My lord, that is also exhibit 11 series. Exhibit 11-1. And these are the bedded tickets of the first part, exhibit 11. Okay, we do deny. नहीं है कुछ
Hmm.
Fifth, the incident occurs fifth, sixth, seventh in two hospitals, both government hospitals. She narrates suicide accident, suicide accident. After eight, the parents and the police come, it becomes, my lord, that I court case. The taxi driver who took her to the hospital, the neighbor who took her to the hospital, both say that she said about accidental burn. The lady even told the in front of all the husband to look after the son. The husband says that you will come back and look after the son. That is the evidence of PW9. Even the nonod of the deceased says that she informed the after the incident to the nonod that this she caught fire while cooking. Evidence of the nonod of the complainant's wife. PW3. Complainant's wife also say that she informed, the victim informed about getting lot of blaze while cooking. %65 burn, accident, cut, and then written suicide by the doctor. That even question was posed to the IO. The IO admitted, yes, it is done by the doctor. The cross-examination of the IO.
Where is suicide point?
My lord, my lord, একটু আমার ওই কাগজগুলো দিন না যেগুলো দিলাম একটু my lord, my lord, একটু দিন এবার এইটা দিন 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 হ্যাঁ my lord sees. My lord sees that document, my lord. First.
Yes, what is?
And this question was specifically put to the IO.
Go through the deposition.
Yeah, I'm praying for days adjourned.
Not this week. Give it to. Accident is makeup. Adjourn.
49, my lord, your lordship has appointed me, my lord, Dulal Mondal.
But so far 50 is concerned, we have completed our submission. Lordship directed us to file our written notes of argument. Okay, ঠিক আছে
Go through it and make submission. You have finished it?
My lord, I have finished, my lord. Only one thing, my lord, if my lordship, if I point out, my lord, from the FIR, my lord, it transpires that that the appellant left the reception ceremony with his friend at 11:30. Now, my lord, if he has left the reception ceremony at 11:30, my lord, he could not have been seen at a different place by PW 6 and PW 18. And if he'd been seen, my lord, then he has left with one of his friend. Then his friend ought to have been seen by PW 6 and PW 18. So, my lord, my lord, this cast a doubt, my lord.
Properly.
All right, we'll keep it on another day.
Right.
Go through the twentieth of March.
देखते 20th of March. तीनटे के कॉपी करो ठीक हो
20. Of March. Sorry.
20 तो
20.
4 weeks from receipt of records by the trial court. আজকে তো থার্সডে থার্সডে পড়ছে তো উত্তেজিত হচ্ছে
Yes.
$51. It's an appeal of 2011. From then, my lord, after suspension of sentence from 2012, I am in custody for near about 14 years.
Sentence?
Sentence imprisonment for life with 376. The prosecution case depends upon two witnesses basically. One is the victim, PW1, and another is PW3, who is, my lord, a 10-year-old girl who had witnessed the incident and has reported the matter to the parents. Now, my lord, this PW3 was examined under 164. That is Exhibit 5. If your lordship kindly peruse the Exhibit 5, if your lordship would see from the Exhibit 5 and the FIR and other stories which are being made up, this is completely stage by stage embellishments. And PW3 speaks of one PW9, who is a near about local lady, along with her, who have witnessed the incident for more than 1 hour.
This is not a gang rape.
No. A single rickshaw puller.
Then how life in this?
I don't know, my lord. And that too, my lord, subject to correction by your lordships, the medical evidence is absolutely scanty.
travel to
Being a married man did not. Oh, the victim is a mentally challenged.
But that, my lord, subject to correction, my lord, by that also there is no document to show. There is no prima facie document to show that she was a mentally retarded child. It was only stated she was 16 years, 16 to 17. In ossification test, she was 16 and a half.
So it does not fall into the aggravated form.
No, my lord, subject to correction.
What do you say?
15 years, she has stated. The 164 of the friend who witnessed the incident, that is there, my lord.
My lord, if subject, bol. My lord, your lordship will kindly peruse exhibit 5 for one. And if your lordship sees PW 5, I think, my lord, the doctor's statement. And his opinion. Page 17, I am referring to the paper book. Thanks.
Where is the age determination?
My age determination is only by PW 4. At page 14 of your lordship.
সোমবার কি আছে গো? সোমবার কি appeal আছে? সোমবার 15 years আছে।
My lord?
15 years to 16 and a half. So in 2011,
yes.
What was the sentence? 10,
10, my lord.
10 to life.
10 to life.
Not 7 to life.
Not 7 to life. It was 10 to life.
ও পরে হবে এটাকে সোমবার রাখছি Monday we are.
Yes.
Further hearing Monday. We'll consider the sentence.
Your lordship will kindly also consider exhibit 5.
We have seen there's nothing to consider there. The injury may not be there because of the state of mind and the incapacity of the girl to resist the rape. So absence of injury and inconclusive opinion with regard to rape does not wash
No,
out.
my lord, that is not subject to correction, my lord. But PW exhibit 5 is the first statement of the PW3.
We are forgetting PW3. Forget PW. We don't rely on PW3. We rely on PW1, the victim. That's good. Yes, please.
My lord, Mr. Patwale is appearing virtually, my lord.
Thank you. Yes, Mr. Patwalia.
Wait, please, your lordship. I'm sorry, my lord, it took this small lag because until your lordship turns it on, I can't join as a attendee. I remain a panelist. So then it takes a few seconds for me to switch over. So I'm so sorry.
No difference.
So, my lord, with your lordship permission, I would assist your lordships from here. Now, the position is, my lord, shall I take your lordship straight away to the FIR, or would your lordship like to see the Supreme Court order first?
No, you take us to the FIR and then
Yes,
you.
yes. The Supreme Court has basically remanded it and, according to me, left everything open. So, there is a compilation which we have filed, my lord, which contains all.
It's an open remand, so all
Correct.
issues are open.
Correct. Everything has been left open. So therefore, my lord,
fully on all points on which you seek to.
Correct.
The relief of quashing.
Correct. So if your lordship will straight away, there is a compilation which has been handed over. Mayunk is there, my lord. At page 29, your lordship may come to that compilation.
Right.
Now, if your lordship will see right at the top, the 1, 2, 3, 4, fifth column says information received at police station date 20th May 2022. Time is 17:20 hours. And it says journal diary reference, entry number so and so. Time is 17:20 hours. So the moment the information is received, it is the FIR is registered, is what I wish to point out. Now, your lordship may kindly come to page 31, which is the information. The complainant, whose name appears at page 33, is one Sariful Islam. Now, I'll take your lordship through it. This is a complaint, my lord. It is made against 7 named and rest unknown persons. The first is Naladri Shekhar Dana, who is actually an applicant before your lordships. He is an MLA. The second is Bankim Chandra Ghosh. He is also an MLA. The third is Dr. Subhash Sarkar. He is a member of parliament. The fourth is Maitri Dana. She is the daughter of serial number 1, who is supposed to have secured this job. Fifth is Deepak Biswas. He is a BJP worker. 5. 6 is Jagannath Sarkar. He is an MP. And 7 is Ramji Singh, who is the director of the All India Institute, and others for commission of offences under the Prevention of Corruption Act. And IPC offences are 406, 420, read with 120B and 34. Now, all these MLAs and MPs belong to one particular party, that is the BJP. Now, the complaint, my lord. I, Sariful Islam, son of so-and-so, am a resident of the address is given, my lord. I am a law-abiding citizen and presently unemployed. I was looking for job opportunities in and around Kalyani for the past several days. Recently, I have come across a shocking piece of news concerning a job scam perpetuated by leaders, public servants, ministers, MLAs associated with the Bharatiya Janata Party, their family members, and other unknown persons, details of which are stated hereinafter. On 19th May 2022, I was made aware through a renowned Bengali newspaper article, Vartaman, that one Maitri Dana, accused number 4, she is the applicant, lord, number 1 before your lordship, has landed a job of data entry operator in Kalyani for a monthly salary of about rupees 30,000. It is 24,800. I will come to those details later. Maitri Dana was handed over the job without her even having taken part in the recruitment test, which was undertaken by all other eligible candidates who had applied for the same position job in the said institution. The said Maitri Dana is the daughter of none other than Niladri Shekhar Dana, accused number 1, who is a member of BJP, elected member of the Legislative Assembly, MLA from Bankura Assembly constituency. Shri Dana had used his power and influence to illegally ensure that his daughter was able to get the said job in AIIMS Kalyani, which is one of the premier medical institutions in our country. It was further stated that Shri Dana was able to secure his daughter's job with the help of Union Minister of State for Education, Dr. Sarkar, accused number 3. As a favor to his friend and colleague, Dr. Sarkar had purportedly taken advantage of his good offices and his position as a Union Minister of State to ensure that Shrimati Dana was given the job. It is further alleged that Dr. Sarkar has got the recruitment done through one Deepak Biswas, who is a member of the State Committee of the BJP. The said Deepak Biswas is also responsible for providing jobs to other close associates of influential people connected to the BJP in an illegal manner. To confirm the veracity of the news, I also checked with other news portals agencies had reported the scam. I also checked whether other news portals agencies had reported the scam. To my surprise, I came across multiple articles which confirmed the aforesaid illegal acts committed by the accused persons. Furthermore, such news portal agencies disclosed that another MLA, also belonging to BJP, had used undue means to land his daughter-in-law a job at All India Institute, Kalyani. The said MLA, who is believed to have perpetuated the act, is Shri Banking Chandra Ghosh, accused number 2, who represents the Chakdaha Assembly constituency. He too used his position as a public servant to help his daughter-in-law secure a job through unscrupulous means and methods. The news articles also stated that one Tanya Bhattacharya, a youth leader of BJP, had accused Shri Jagannath Sarkar, BJP MP from Rangan, to provide jobs in All India Kalyani in exchange of money by bypassing the standard procedure followed for such recruitment. These allegations have been claimed to be true by many other members of the BJP, including Partha Chatterjee, Dalip Ghosh, and others. The entire incident shows it is a concerted effort made by highly placed and influential members of the BJP to provide jobs to their near and dear ones and denying opportunities to deserving candidates. I am enclosing copies of all news articles which have been published in Bengali newspapers like Bartaman, Anand Bazar, Kolkata TV, so-and-so, along with English translations. It will not be out of place to mention here that us locals who live in and around Kalyani and or within Nadia district have been attempting to secure a job through All India Institute Kalyani has to offer. We were made to believe that with a premier institute like AIIMS being set up, the locals will have job opportunities. Issue of unemployment will be addressed. We have gone pillar to post, and some of us have even taken part in multiple test examination to land a job in central government institution. However, the various news articles have opened my eyes to the fact that us locals never really stood a chance against such power-yeeking public servants who were elected by us to help protect us, etc. Then, to further corroborate and substantiate the information, the said news articles also cite one Partha Chakravarti, who is reportedly a member and local leader of Bharatiya Janata Party. He stated that I have written to Amit Shah ji and have informed him how 2 MLAs have used their position to help their daughter get jobs in the hospital. These political leaders are fulfilling their personal agenda in the party by using their portfolios. Statement clearly indicates that being a local political leader of BJP, Shri Chakravarti is well aware about the illegal appointments going on in the central institution. He is aware as to who are the political leaders behind such illegal activities. These illegal acts assume importance in the light of the recent SSC corruption scam in Bengal, as the BJP leaders' claims of being honest and law-abiding party falls flat in its face. Such acts have shaken the confidence of the local people in the central leadership, which is responsible for various premier institutes. Recruiting candidates based on their background connection instead of merit will also adversely affect the services rendered in these institutions and bring shame to the institution. In the light of the above, it is amply clear that leaders of BJP, including public servants like accused persons, are misusing their position power to make illicit appointments in favor of their own near and dear ones. In order to do so, they have connived and conspired amongst themselves and have taken into confidence the director of the institute, namely Shri Ramji Singh, accused number 7, to allow accused 1 and 2 relatives to be illegally recruited in the institution. The role of Ramji Singh is vital in the entire scam, since without the director's knowledge and information, such illegal appointments would be practically impossible. It is also pointed out that accused persons number 1, 2, 3, 5, and 6 are all affiliated with the ruling BJP. 4 is the daughter Malad at the center, which is responsible for running such premier central government institutions. Together, they have used their connection, influence, and power to obtain undue advantage to ensure that improper, dishonest, illegal acts are committed, so as to ignore the recruitment test taken by hardworking individuals and to pick and choose candidates as per liking. Involvement of so many elected public servants and the top brass of the institution must also involve giving illegal gratification so that such scams are pulled off with ease and without attracting undue intimation. So it says he must also involve taking gratification. The common man has been cheated by the persons. Strict action should be taken. Then Melody says treat it as an FIR and please lodge an FIR. If your lordship will see below the stamp, it says received on 20th May 2022 at 17:20 hours. So the moment it is received with such sweeping allegations focused on a party, I'm not for the time being going to go there, but with such sweeping, there is no preliminary inquiry, nothing is done. Immediately the FIR is registered. Now, after the FIR is registered, they issue summons to both the petitioners as witnesses without even giving a copy of the FIR. I will go there a little later, and I had to move court to get a copy of the FIR, which I have stated in my petition. And when I got the copy of the FIR and realized that I am actually an accused, then I moved this petition seeking quashing of that FIR. Now, my lord, so far as there are very wide sweeping allegations, but I will focus first on what is against me, what is the nature of my appointment. According to my primary submission is going to be, after I show your lordships my appointment letter and the contract and documents, that my appointment is on contract. It is a deployment and outsourcing actually with a private agency and not with aims at all. And therefore has no character of a public appointment. And then my submission is going to be that even if your lordship comes to the conclusion that the appointment is, there is a distinction between an illegality and a crime. So therefore, kindly now see what is the nature of my appointment. My appointment letter is actually at page 34 of the paper book. Kindly see that. And then I will show the agreement or the basis of that appointment.
Revisional application.
Your lordship has seen the allegations are sweeping, but there is no particular allegation against me that X amount of money was paid or this person's influence was. It's not. It's a sweeping omnibus allegation which is made. Now, what is the nature of the appointment, therefore, becomes very crucial to see if any crime is committed here, which answers and attracts section 406 or 420.
Yeah, Corruption Act charges also.
Yes, no, charges are there. Charges are section 7, 7A, 8, 11, and 13. And that also I will meet. In fact, my case is that this was a contract for 4 months. And the very essence, your lordship may just see this, because unless I read that agreement in my letter,
if illegal contract for supply of goods are given, is it not an act of corruption without following due process?
My lord, this is quite different, because there is no illegality here. Just kindly see those 2 documents with me before I make a further submission on this point. Just those 2 documents.
Consequence whether the post is a public post or is a contractual post.
Yes.
If a benefit is given to someone by a public servant or a public institution, and that is an undue advantage, it is an act of corruption.
Well, the submission is going to be that so far as this is concerned, number one, there is no, just kindly see these 2 documents and then I will make this submission further. Kindly see my appointment letter and the nature of the contract entered into between the 2. Just kindly see page 34 of the of the paper book where my appointment letter is there.
Page 34 of the revisional application.
Yeah, of the revisional application.
Yes. आपके दिए sir?
No, দুটো copy file হয়েছে। You have given the other copies. You filed it.
One second, Mr. Patwali, I think the other copy has to be trusted.
No difference.
The last occasion, my lord, we had supplied it, but we'll again give another. Huh? I know. Leave it on. Extra copy আছে। But I have an extra copy, my lord, but it is marked, my lord.
Marked copy, how will you?
My lord, we have already given, my lord, before your lordship, my lord, had fixed it for hearing, we had already given a copy.
Judgment, this is not the copy. Judgment is there, list of dates are there, and index.
But your lordship has the revision application.
Sir, the problem is the revision application was before the single judge.
Oh.
We were under the impression that a department has prepared a second copy for my brother.
Okay.
Mr. Mukherjee, Mayuk Mukherjee says that he had supplied the second copy,
Second copy. All right.
Before us today. It's a bit of a hitch.
Only difficulty, my lord, I have a marked copy, my lord.
That
I know, my lord, which is why.
Mukherjee, this is not proper. Your brief cannot be handed over to a judge.
That is why, my lord.
This is very, very.
I had handed, but we had handed over, my lord, before the hearing had started.
He did. It's a bit of a logistics problem.
All right. Then we can have it on the next occasion, or I can just take your lordship through the. But my way of putting it, I thought this was very important, madam.
Just summarize the points, and then on the next occasion I will prepare and submit the second judge's copy.
So, my lord, my point. Actually, my lord, before I even summarize, please see one more document with me. Please see.
Mr. Patwalia, 1 second. Let me just formulate what you have said till now, so that if we have incorrectly understood you, please correct us. First, you have said that the FIR is a sweeping FIR, sort of encompassing everyone belonging to a particular political group.
Correct.
Right. And the minute it was lodged at the police station, it was registered without even making the slightest preliminary inquiry with regard to the nature and scope of the allegations.
Correct.
This is the first point.
Correct. And since all appointments are to be made on the recommendations of the director, therefore, Section 17A is the second procedural requirement which would come in.
You have not addressed.
Yes, I have not so far now. Yes.
So just that next thing that you have said is this appointment is a contractual appointment through a labor contractor, and therefore it is not an appointment to a public post.
Yes. I will further buttress it by saying my salary is not paid by the All India Institute. The All India Institute pays the contractor. The contractor has responsibility of giving me my salary. And the contract which All India Institute has entered in with the contractor puts it as a outsourcing deployment. So therefore, if it is an outsourcing deployment where the salary is paid through the contractor, it is in the nature of a private employment.
We have understood that the salary was by the contractor, and therefore the employer-employee relationship is between the contractor and the contractee.
I may underscore here, the contract says All India Institute is the principal employer. So your lordship gets that whole picture.
Under the Labour Contract Act.
Correct. So that contract refers to the All India Institute as the principal employer who will pay the money to the contractor,
Correct. It is basically the contractor being the intermediary through which the payments were made.
And the employment was for 5 months, which 5 months got over in August, on 28th August 2022, at a fixed salary of 24,000 rupees.
Those submission, all right, we consider that. That 5 month or only 1 month, they will be the quantum of the offense or the gravity of the offense. When we test the premise on the anvil of jurisdiction of registration of FIR, even if there was a day's appointment, it would be an offense. Whether it would be something to be really of such nature that it would attract graver punishment, etc., are not matters which we require to trouble ourselves on. We need to see whether this act, the allegations in the FIR, connecting the applicants before us, this prima facie disclose reasons to suspect the commission of these offences. And if they do, whether Section 17 capital A get attracted for the registration of this FIR or not. This is perhaps two of the main.
These are the two major points, Lord. These are the two major issues on which we are.
Mr. Patwalia, I'll be very clear to you. The second point is something to be looked into. The first point about sweeping allegations, we would have looked into them had it been the applicants were someone which are outliers to the alleged conspiracy, like the member of parliament and some political leader, etc. Before us are two persons, one who got the so-called undue advantage of being appointed through contract or otherwise, and the other being her husband, a political personality who is alleged to have leveraged the power broker to get the appointment. So here the allegation is very crystallized. The
Lordship will also
penumbral allegations, and penumbral allegations, I completely agree with you, are very vague.
Correct. So therefore, that is something which your Lordship will see. Just because I happen to be the daughter of an MLA who has got a contract for 4 months, it will, this kind of sweeping presumptions.
That we will like to know how you got appointed. Was it an walk-in interview?
It was a process of test where I could not secure the marks. The director makes a recommendation, and on that recommendation, I will take your Lordship to that.
That issue is a matter we have to look into, whether the director can make a recommendation like that.
Yes, I will. Once your Lordship reads the contract, that is all part of, it's all there in the contract.
Okay, next day we'll keep this.
All right.
Who will appear for this? Public prosecutor.
So any Thursday convenient to the court, my lord, other than 13th, any Thursday.
You tell us which date is convenient for you.
20th is also all right, my lord. I can come on. I very much want to be there, my lord. Today I just.
But Mr. Patwali, it will be 20th if you want, will be at 2 p.m.
Or the week thereafter, if it can be in the morning, my lord. Whenever your Lordship has some, or even, it's okay. Even 2 is okay, my lord. I have no problem.
No problem.
No issue.
So 20th at 2 p.m. we can keep it.
All right.
20th, 2 p.m.
All right. Or if it can be a week thereafter, my lord, 27th, if it's not.
1 second.
27th.
Tell us any day which is convenient for you in that week, the next week, the week thereafter.
No, then let it be 20th. 20th is all right. No difficulty. 20th.
That week thereafter you want, we are open for every date.
Then 27th is all right. 27th.
27th you want.
Correct.
27. All right.
Yes, ma'am.
You want in the morning.
No, whenever, my lord, your lordship has other things on the morning, I am okay 2 p.m. also. I have no issue. Morning is also okay. Whenever your lordship has time on 27th.
No, 27th, we will keep it in the morning.
Grateful. Grateful. I'll be there. I'll be there.
We have some miscellaneous matters. So what we may hear you for an hour, the way we thought we'll be hearing you today.
All right.
If you finish your arguments, then we'll go for the miscellaneous matters.
All right.
All right.
All
So in the morning, we'll keep it.
All
Let's
right.
10:30, it would start.
All right. Grateful.
Mr.
Grateful.
We'll do that.
As your lordship, please.
Heard Mr. Patwalia and Mr. Mojumdar for the petitioner. Stop. Matter is fixed for further hearing on 27th March 2025 at the top of the list.
Grateful.
Thank you.
Grateful. Very grateful.
Interim order granted earlier shall continue till 28th.
Till tomorrow it was.
Acha, till 30th of April or until further orders, whichever is earlier.
Grateful. Grateful. Grateful.
Thank you, sir.
Grateful.
Yes, my lord. Give it back.